America, wake up or die.
All right, we're continuing on private prosecutions, and today we are going to look at Minnesota Law Review because, if we see the problem, you can bet your bottom dime that the people in the legal society see the problem too. And guess what? They write about it. Wonderful. That way nobody can be like, oh, who's this guy? He doesn't have a law degree. Let's just discredit him. No, I'm just going to use your own people talking about it. I mean, if you want to discredit your own college professors of law, I could get behind that too, believe me. Anyways, okay, so here we go. It's talking about a second model for minimizing unjustified failures to prosecute relies on private actors to create redundancy with public prosecutors' authority. Huh? You mean if we actually want to see real law being upheld, we gotta do it ourselves? We gotta do it ourselves? Is that what you're saying? I think that's what they're saying. Empowering private actors to file and litigate public law claims is familiar in many civil law contexts. Numerous federal statutes authorize private rights of action that enable private individuals or groups to supplement public agencies' law enforcement efforts. And we're going to get into that before this series is over. Believe me, there's a reason I'm bringing it up. Through much of the 19th century, this kind of duplicative public-private enforcement authority was a familiar feature in the criminal justice system of many states, which permitted private parties, victims, to prosecute alleged criminal wrongdoing. Yep, that's how it used to work, and if you watch my series on grand jury indictments, you'll probably pick up on that, because it used to be your job to prosecute wrongs that happened to you. You want to know why? Because nobody cares about you anyways. And they didn't have the resources. They weren't robbing everybody for a third to a half of their paycheck, so they didn't have the resources to have all of these public functioning prosecutorial agencies that don't do their job. They just didn't have the resources for it. Okay, down here it says, A. Sources of unjustified non-charging decisions. Public prosecutors are the gatekeepers of criminal law enforcement, and justice systems employ a variety of safeguards against prosecutors' misjudgment, bias, incompetence, or laziness. Most are directed at prosecutors' charging decisions rather than decisions declining to charge, i.e., declination decisions. For familiar reasons, charging creates real burdens and risk for defendants. So basically, and you hear this a lot, we got to uphold the rights of the defendants. We got to uphold the rights of the wrongdoer. In fact, that's what Greg Newman said, which was why he had to let the child rapist go, because that guy has rights too. Yeah. That's what he said. Under oath. Verified, son. Alright. The primary cause of under-enforcement are failing to investigate and charge due to biases against certain victims or harms, or favoritism towards certain kinds of suspects. 3 kinds of crimes: local government corruption, sexual assault, and unjustified uses of force by law enforcement officers, illustrate the link between these risk failures to enforce and the consequences of under-enforcement. Local corruption garners the least public and political attention right now. See, we got to change this, because that's probably the biggest problem. Just my opinion. That's not a fact. This law professor didn't write that. He just wrote that it garners the least public attention. He didn't write that's the biggest freaking problem. Crimes of corruption by state and local officials are a good example of harms that, at times, criminal justice systems have unduly ignored. You know what that means? It means that they've ignored it legally and lawfully. Not even going to try and be smart with this one. Local police and prosecutors are not institutionally well suited to pursue and evaluate those crimes. They often have professional, if not personal, ties to other local officials, which heightens the risk of undue favoritism in judgments that are otherwise not fully disinterested. You think people working in the same office in the same criminal enterprise are going to turn each other in for their criminal activities? I mean, do we really have to have people with doctorates in law to tell us this? Really? In the wake of victims' rights movements in North America and Europe, crime victims now have an array of legal rights once criminal charges are filed. Victims in the U.S. and European jurisdictions now commonly have rights to participate that include rights to consult with prosecutor, to be notified of and present at court proceedings, and to offer statements at such stages such as hearings on bail, sentencing, and parole. Most rights are specific entitlements to advance victims' broader dignitary right to be treated with fairness and with respect for the victim's dignity. These provisions conceive of victims as agents of individual rights and independent from the systematic interests, and their interests can either conflict or align with those of law enforcement. At the same time, victim participation rights can also be understood to serve a broader public interest in procedural outcomes on the premise, for example, that prosecutors' and judges' decisions will improve with direct input from the victim. Public decision-making risks substantive deficiencies in criminal process would be procedurally deficient without due regard for victims' interests. Jurisdictions that empower victims to challenge non-prosecution decisions enable private parties themselves to address the problem of criminal law under enforcement. So, let's just talk about this for a minute. You want to know why there's nothing called the Victims' Bill of Rights in the actual Bill of Rights of the Constitution? Let me think about this for a minute. Oh, because you prosecuted your own claims. Yeah, that's why. Because there were no such things as victims. There were aggrieved individuals who were seeking justice through the courts. And they got it because ever since the time of the Magna Carta, in our open society, the English common law system, it's always been prevalent that people have had the right to access courts for any wrongs done to their persons or property. And they could access the criminal side of the court and they could prosecute their own crime, because kind of like in that other video where I showed you, the definition of a prosecutor is the chief witness before a grand jury or a petite jury. It's kind of the definition. See, another man, another woman can't prosecute your claim on your behalf. You want to know why? Because in law, they don't have any standing. They don't have any standing. That's why. If you want the real quick, easy, boom, here it is. Because you see, they call these things like Victims' Rights Acts, and they have like the Victims' Bill of Rights in certain constitutions. But let me tell you a little story about a gentleman named Greg Newman. He violated all of them. And you want to know what happened to him? Did he go to jail? No. Did he get disbarred? No. He got a suspended suspension and paid less in fines than I got in speeding tickets. So apparently society is telling you it's less of a crime for a district attorney to let child rapists walk and completely negate victims' Bill of Rights than it is for me not to register my car or pay insurance on it. What kind of sense does that make? What kind of sense does that make? And guess what, public? You're the ones financing it. You're the ones financing it. The people are financing their own enslavement. That's what's going on. That's what's going on. So, anyways, I just wanted to make really, really clear that, victims' rights are a joke. They're a joke. They're saying that you have no rights, that they're going to give you the privilege of maybe they'll prosecute and do something someday, but if they don't, you don't have any rights, you don't have any power. You can't access a court of law. You want to know why you can't access a court of law? Because slaves have never been allowed to access a court of law. Only with people with rights can do that. You think Bill Gates can't access a court of law? Alright. A criminal enforcement regime that relied heavily on private plaintiffs would be one skewed against redress for poor victims who cannot bear litigation costs to vindicate their own interests. Without safeguards, such a regime also could be at the mercy of the varied, perhaps idiosyncratic motives and interests of private actors lodging criminal complaints. Still, many countries continue to authorize private citizens to initiate criminal prosecutions when public officials do not, and others allow privately funded attorneys to assist or supplement public prosecutors in litigating criminal cases. Among these are Canada, Australia, New Zealand, and England and Wales. All continue to allow private prosecutions. Take that, progressive America. So, in other countries, in other common law countries, they still allow private prosecution. Just not here in the United States, because, we're the home of the free and the land of the brave. Apple pie! Public corruption, corrupt conduct by government officials is a category of wrongdoing especially likely to suffer from under-enforcement. You think? For obvious reasons. Obvious. We depend on one set of public officials, prosecutors, and investigative agents to stop wrongdoing by other public officials, as well as by colleagues within their own ranks. Professional and even personal relationships often exist between these groups of public officials. Even when the boundaries between lawful and unlawful conduct are clear and law enforcement can learn of misconduct done mostly in secret, political or personal incentives for law enforcement officials that discourage zealous enforcement can exist for enforcement officials in the same jurisdiction, perhaps enmesh in the same political networks. In short, under-enforcement in this realm follows more from favoritism towards offenders than the biases against victims groups or types of offenses. Corruption is a notoriously hard concept to define, but that difficulty is actually somewhat useful for present purposes. Some of what constitutes public corruption is relatively clearly defined in positive law. Easy cases involve straightforward property theft or embezzlement, quid pro quo, bribery, and extortion. Statutes also make clear at least some cases of illegal, gratuitous, and breaches of regulations that govern activities such as campaign finance. More ambiguous or marginal cases of alleged corruption, however, illustrate the federal government's ambitious commitment to enforcing broad interpretations of federal anti-corruption laws to conduct of state and local officials. And this is why we got the federal system that we have today is because when you start handing individuals power, absolute power corrupts absolutely. And what happens is that those local gangsters that you call your local public officials get so bad in some areas that the government has to come in, the federal government has to come in and bust them up. And here's what happens. It's like when a bigger gang comes in and destroys the smaller gang, and everybody's like, "Yay, we're free!" And then the bigger gang's like, "Well, I wouldn't exactly say that. I would just say, you're more under new management." That's what's really going on. And this is going to go on unless people actually figure out what law is in their heart and then they do something about it. Because I can guarantee you that if public officials knew that private persons could bring private prosecutions against them and drag them into a public arena, that might not change their behaviors overnight, but I bet it changed their behaviors really quick after a couple of people started doing it. That's just my guess. It's just my guess. Anyways, I've been doing a bunch of digging and research, and I got a little video. Everybody knows Angela. Everybody knows Angela. I don't have a picture of her daughter right now, but I got a video of I remember on that video that I made, Megan Fox was talking about how Angela's daughter's stepsister left home, because she was being abused. And I have a video clip of her while she was still at the house. And that's how I'm going to end this video. But I got a lot of stuff coming up, so please stick around. Learn about private prosecutions so that you can try and convince somebody why we should bring them back, why we should have them. I am just conspiracy, and we just wish to conspire with other good people of this planet to try to maybe leave a better world for future generations than the world we all grew up in. But right now we're just trying to conspire to make sure that children don't get ripped away from their parents. So if you can get down on this conspiracy with us, we'd love to have you. And if you can't, well, pick a number and wait in line for the government to come and rip your children away from you. One world, love, and peace.
When was the last time I broke anything besides fucking pie on your face? You broke the laptop, you broke the fucking door. I broke the laptop on the back of your fucking head after you put your hands on my daughter. Well, what? Fucking psycho. I am done with you. This is bullshit. That is bullshit. You know what? You should go to James, you're a fucking bully. Fucking do it then, James. You act like I'm the one that's gonna go to jail. It'll be you. Whatever, what I fucking do.